Hello, this is Ian Gascoigne. I'm presenting a webinar for MBL entitled Combating Contractual Disillusionment and Disputes. It's a fairly long title, by which I mean parties to a contract may become disillusioned in the performance of that contract compared with their expectations when they entered into it. That sort of feeling, particularly in an important matter for a party, makes fertile ground for a dispute happening. And that's what everyone wants to avoid. So the anticipation is, how do you actually prevent disillusionment or deal with disillusionment so as to preclude the dispute happening? Sometimes you won't be able to do that. And sometimes your reactive steps or proactive steps sometimes can help to prevent that dispute emerging and make parties happier than they were, disillusion going. That's the idea anyway. So I'm looking at different types of contractual claims. And those can be as straightforward as a debt claim under a contract where money is owed, it just hasn't been paid. Proving it hasn't been paid is quite straightforward, to the much more complicated situation which we find in commercial litigation, where there's a complex contract with obligations on both sides, and they fall out as to what those obligations actually entail. And there may be a misunderstanding or misapprehension as to what is required, which leaves each side saying that their version is correct, and that's what they insist on. And that leads to a dispute if that matter can't be resolved. So we're looking at scenarios which can be straightforward debt claims to very much more complicated commercial disputes arising under a contract. There's quite a lot of legal material I could cover in this webinar, and I had to be selective as to about what I thought was appropriate. So I've selected four topics to consider. Those topics are the formation of a contract, which would include, although not in great detail, estoppel and misrepresentation. Second, the non-performance of a contract, which requires a breach to be established or proved. Third, if that is established, what are the remedies for that wrong? And finally, my topic of avoiding performance for impossibility, where it simply isn't possible either completely or temporarily to perform the contract at all. Obviously, those are not the only areas of contract law which give rise to disputes and disillusionments, but those are the ones which I've selected for this presentation as being ones which commonly give rise to problems in practice. In illustrating these points and working through them, I will be looking at cases decided or reported only in 2024. Sometimes I may mention a case preceding that where it's important to describe the resolution of the case. But remember, I'm not necessarily talking about how the courts resolve the problem. I'm also looking at how practitioners can advise their clients to do so as well.